with them. So, all right. Okay. Hello and good evening, everyone. I welcome you all to Lecture 3 of the ongoing certificate course on disability studies being conducted by Center for Disability Research and Training, Kirorimal College, and National Center for Promotion of Employment for Disabled People. It gives me immense pleasure to now hand over the platform to our efficient resource person, Advocate Subhash Chandra Vashishtha. Sir, I'll be there to moderate the question and answer session, as well as I'll be handling the chat box. So over to you.
Thank you, Yashaswini. Yashasvi, right? Is that correct?
Yes,
Okay.
yes.
Thank you, thank you. So let me just share my slides. Is that sometimes this really doesn't work.
It's visible, sir. Is there a network issue, sir?
Is that okay? Is that
Yes,
okay?
yes.
Okay, great. Okay. So a peep into the history. Are you able to see my slides, right? You're able to see
Yes,
my...
sir.
Great.
Perfectly audible, perfectly visible.
Okay. So as we see, we had done last time, but just a little, peep into the history. As we did last time, all domestic statutes in the country, in India, they derive their roots from the Indian Constitution. And that includes the disability legislation. So in principle, the roots are in the Constitution, but definitely the push and the impetus has come from India's commitment to the UN Convention on Rights of Persons with Disabilities that India has signed and ratified. As I shared last time, so there was no disability specific legislation until 1995. I don't count the 87, the 86 and 87 two laws into rights-based disability specific legislations, because they were more to control and regulate the trainings of professionals in disability in form of the Rehabilitation Council of India Act 1986 and the 87 Act, which was a Mental Health Care Act. It was more on clinical models. So for the first time on disability, 1995 Act can be said to be the first act which had certain rights and which were right-based. Of course, subsequently, when we used that law, we realized that this also had some smell of charity. And so therefore, in light of the convention, we needed a better law. So before this 95 law, the Constitution of India held the forte, and it provided remedy and relief to Indians with disabilities. So all major cases that we fought during those times before the law came in being, we were filing all these cases as writ, under insisting on claiming our fundamental rights of equality. So in 80s, as I just said, with a lot of advocacy and major initiatives by international bodies, the focus had shifted to provide rehab, health, and which led to these two acts. So I count them more as laws that were trying to fix people with disabilities from the perspective of medical model. So fix them so that they can become all right. Of course, it did improve the lives of persons with disabilities, but definitely it can't be said to be a very right-based acts which were led or which had major role to be played by persons with disabilities. So in these laws, we would find that it is the rehab professionals or the therapists, the doctors, the people who are giving treatment, they had larger rights. It is actually was to regulate them. February 96, we saw this wonderful act, first act 1995, notified, and the full form itself of the act, though it was called like PWD Act, but if we saw the full form, it actually also clarified the mandate of the act. And the mandate of the act was equal opportunities, protection of rights, and full participation act. Now when on 28th December, the President of India, this was notified in the official gazette, and a day before President of India gave his assent on 27 December, this act, which is 49 of 2016, came into being. You'll find in this, there is no mention of equal opportunity or protection of rights. It is simply the Rights of Persons with Disabilities Act. And you'll find the name is very, very similar and it takes the analogy from the UN Convention, which says UN Convention on Rights of Persons with Disabilities Act. So what an apt name. So that there is so much in name as to how society uses the terminology to address issues and empowerment of persons with disabilities. So 19th April 2017, this act came into force, and 15th June 2017, we had, because every act in order to be being implemented or given, इसको हिंदी में हम कहें तो अमली जामा पहनाने के लिए, we need rules, bylaws, subordinated legislation. So RPWD rules 2017 were issued on 15 June 2017 in the official gazette, and it came into effect. So that is, it came into force on 19th April, as I just said. So let's see, if we see from the terminology itself, how the Act 949 of 2016 starts. The first line itself indicates the purpose of it. So the act is to give effect to UN Convention on the Rights of Persons with Disabilities and for matters connected therewith or incidental therewith. And then the history and then repetition of, I think, these principles, which I enumerated on the last lecture. And I think this is always good to come back to these principles, because they actually forms a very basis of the UN Convention, and as well as the act which was enacted to implement the convention, which is, I repeat, respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of person. So these things, underlining the term independence of persons, non-discrimination, full and effective participation and inclusion in society. So you'll find a lot of these principles are also coming from the earlier name that we had. Respect for difference and acceptance of persons with disabilities as part of human diversity and humanity. Some people might say why this D was added. This D was added to actually disregard the whole focus on medical model, which did not respect the differences and which would actually focus on fixing the people's disability. So we had to accept people with the disability, and there has to be a respect for difference. And then equality of opportunity, accessibility as a major principle for empowerment, and equality between men and women. So not just equality of opportunity, but also the equality between men and women, so that we have seen in the past that there has been more focus on men rather than being women. So that was also underlined. And last was respect for evolving capacities of children with disabilities, and respect for the right of children with disabilities to preserve their identities. So the disability identity itself is a huge, huge area where we can actually have separate sessions. So just moving on next. The salient features, if I want to share with you, is that it actually replaces the earlier act, which is the PWD Act of 1995. It replaces that, it repeals that. And for the first time, it defines disability as evolving and dynamic concept. So it doesn't remain constant, it keeps changing, and then it is constantly evolving. And for the first time, it said that all persons with disabilities, irrespective of their degree, so whether you have a 1% disability or 39% disability or 80% disability, all are entitled to non-discrimination. Unlike the earlier act, which did not even accept persons with 39% disability as persons with disabilities. Wide coverage this time, about, as we said yesterday, against earlier 7, we have 21 categories of disabilities or disabling conditions. There are gender-specific clauses for the first time because it deals with gender sensitivity in certain chapters like health, social security, and others. It also speaks about reservation in education and employment, but you will see the reservation is given to the benchmark disability. I'll come to that. So for all government schemes where reservation is needed, then you need a degree of disability. Of course, that becomes important. Otherwise, for all other issues, yes, you are entitled to non-discrimination. Inclusion of private sector is a major landmark change that has happened in this law. And it actually provides a definite period for all private sectors also to make their organizations disabled friendly. Accessibility this time has been given a major focus, and in fact, several sections are on accessibility of different things. For example, it talks about standards. We'll be dealing about it in detail, about transportation, about ICT, about consumer products, about so many things, right? Even access to justice and access to voting. So all that, you'll find access words repeated, multiple times in the act, and access not just limited to built environment or ICT or products. Financial support to persons with disabilities is also majorly covered, where it talks of national and state funds. So these are salient features. We'll go into them one by one. It also has regulatory and grievance redressal bodies to monitor the implementation of the act. And then there's right to free legal aid. There are penal provisions, and that we'll talk about. And there are special courts for the first time that this law provides to handle the cases of persons with disabilities. And for employing people with disabilities, it also talks of involving private and public companies. And inclusive education and vocational training opportunities also is a major part of this. So as we begin with the act, it's important to see some important definitions, which forms the very basis, because in the earlier law, many of these things were not defined, and it led the whole space open to interpretations, and interpretations can always be very subjective. Though the courts have consistently said that when two interpretations are possible, the one that favors the marginalized section, the one that empowers the marginalized people or vulnerable groups for whom the beneficial legislation is created, that should be adopted and that should be preferred However, in practice, we have always found that these interpretations that are more beneficial to the organizations were sort of professed and implemented by the organizations. And each time people were made to run and knock at the door of the courts seeking justice. Sometimes justice happened, sometimes it got delayed. And as we commonly say, justice delayed is justice denied. And in some cases, because it deals with a lot of subjectivity in some cases, yes, we had also negative experiences from judiciary. So coming to the various definitions. So the Act defines persons with disabilities, and there are almost three major categories of persons with disabilities that Act talks about. So first of all, it accepts any person as a person with disability, irrespective of his degree of disability. And the only condition is that person with disability would mean a person with long-term physical, mental, intellectual, or sensory impairment, which in interaction with barriers hinders his full and effective participation in society equally with others. So you'll find this definition actually promotes and practices the social model of disability, which we discussed in the last presentation, in the last training program, and which revolve around that the society creates barriers rather than the disability that people have at the organ level. So organ level, it can be an impairment, but it becomes a disability when the person's conditions or disabling conditions interacts with the environmental barriers. And environmental barriers can be physical, attitudinal. I think we did study that in the first session. So there could be attitudinal barrier, infrastructural barriers, environmental barriers, policy level barriers, information level barriers, etc., etc. Coming to next category of disability that is defined by the law, which is persons with benchmark disability. Benchmark eventually is very similar to what earlier we had, which is a person having not less than 40% of a specified disability. Now, specified disability is given in the annexure, where, as we said, that we have instead of 7, we have now 21 of these specified disabilities. And the third category of persons with disabilities is persons with disability having high support needs. So it actually, this law accepts that there will be a category of persons with disabilities who may not be empowered unless, or may not be helped unless by merely giving reservations or by merely giving anti-discriminatory laws or treatment, but they might need high supports. I mean, they might need supports that may be needed a little more than what other people may need. I would request one Tinku Das perhaps is scribbling on the screen. I'll request if you could just undo this, because this is blocking my screen. Thank you, Tinku Das.
Sorry, sir. It happened unknowingly, sir. Sorry, sir.
Oh, I see. Okay. But it seems I could see who's scribbling, so I could see the name and I could read that out. Thank you. So person with high support needs, it would mean a person with, of course, person would be a benchmark disability, but the person will have higher degree of disability, which eventually will be assessed under the provisions of this law, who will be assessed by a board. We'll study about this. So there are three categories of disabilities which are defined in section 2S, R, and T. And high support is also defined as to what high support would mean. So I've put all the relevant definitions together so that it becomes easier for you to understand and have a comparative view. The high support would mean an intensive support, which can be physical, psychological, and otherwise, and which may be required by a person with benchmark disability for daily activities. So it may be activities of daily living, ADLs, or to take independent and informed decisions, to access facilities and participating in all areas of life, including education, employment, family and community life, and treatment and therapy. So that's what high support needs would mean in terms of this law. We did touch upon few definitions, but I thought these are again important, and it is good to always reinforce these. So barriers has been defined as any factor, including communicational, cultural, economical, environmental, institutional, political, social, attitudinal, or structural factors which hamper the full and effective participation of persons with disabilities in society. So these are the barriers that are referred to in the definition of persons with disability in the first definition that we just saw. These barriers in interaction with barriers. So these are those barriers. I hope you're getting a clearer picture that if you have communicational barriers, cultural barriers, economic barriers, environmental barriers, institutional barriers, political, social, attitudinal, or structural barriers, they need to be removed. And it's not just persons' impairment at the organ level, which is responsible for his non-participation, but the barriers that need to be removed. It also, you will see the barrier definition also has a term called communication. And communication has been further defined for the first time in a law in India. And it is not just verbal communication or written communication or just limited to a sign language. It goes much detail. And it says communication means and formats of communication, languages, display of text, braille, tactile communication, signs, large print, accessible multimedia, written, audio, video, visual displays, sign language, plain language, human reader, augmentative and alternative modes and accessible information and communication technology. So we'll see communication has huge further detailing so that this is actually understood by the right authorities, because eventually when you go implementing a certain law, authorities say, "Acha likha kidhar hai wo bataiye," where it is written. So it is. So we insisted, and the sector insisted that it is there in the act. Everything is defined. Similarly, inclusive education is also defined, that you can't just have a school labeled as inclusive school by having children in the same campus but not studying together. We had seen in the mainstream schools students in separate classes with disabilities, and other students, non-disabled students, are in different classes. So inclusive education is defined as a system of education where students with and without disability learn together. And the system of teaching and learning is suitably adapted to meet the learning needs of different types of students with disabilities. And this inclusive education is accepted as a philosophy, as a practicing, as a practice of implementation of education. I'll request somebody's mic perhaps is on, if they can just, microphone can be turned off. Thank you. Discrimination and reasonable accommodation are again very important, because discrimination is defined in this act in relation to disability. When we're talking of discrimination in relation to disability, it would mean any distinction, exclusion, restriction on the basis of disability, which impairs or nullifies the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedoms in all these areas, which can be political, economical, social, cultural, civil, or any other field, and includes all forms of discrimination and denial of reasonable accommodation. You will see discrimination also includes reasonable accommodation or denial of reasonable accommodation, and reasonable accommodation is again is further defined. I think this also appeared in a very major case law, and which actually catapulted the whole explanation of what would mean discrimination on the basis of disability. So it means necessary and appropriate modification and adjustments without imposing a disproportionate burden or disproportionate or undue burden in a particular case, to ensure persons with disabilities the enjoyment or exercise of rights equally with others. So that's what the law defines. And I think it's always important, whenever in doubt, we can always come back to section 2, which forms a very basis. And each time I see myself that when I go through section 2, my knowledge, my learning, it gets further refined. So it's always, whenever you have a doubt, I suggest all of you come back to section 2, read the definition word by word, and things become so clearer to you. For the first time again, the establishment has been defined and what it would include. In the earlier law, we also had several case laws interpreting as to what establishment would mean. And in the last law, the 95 law, we had a few cases where interpretation was done to include even any organization, any trust, any society, or any organization under the Shop and Establishment Act to be an establishment. But there was still a lot of debate around it, whether it will be considered as establishment, because High Court and the other superior courts had decided that establishment under the earlier law would mean only a government establishment, and therefore all the rules of reservation and other benefits and other will apply only to government establishment. But this law defines establishment to include government establishment and private establishment both. And you'll find in certain sections, wherever the term establishment is used, you should understand that this section is applicable to both the government as well as private establishment. And wherever in certain section, the term government establishment is used, then you should understand that this is only applicable to the government bodies. So what is private establishment? Private establishment would mean any company, firm, cooperative, or other society, associations, trusts, agency, institution, organization, union, factory, or such other establishment as the appropriate government may by notification specify. So it has actually defined it, but then also at the end of it, left it to the appropriate government, which means giving little more authority to the state governments to decide as to which are the organizations. So I find this as a little loophole because it gives the appropriate government to also decide by notification that who are the establishment that will be governed under this particular act. So this leaves a subjectivity, and I find this to be an area of concern, though the larger understanding is that the law has clarified that all these that are defined here would automatically come and the state can always supplement it. But some in practical cases, we have found some states also going reverse and trying to do their own notification and excluding some of them. Government establishment, as you know, it would mean a central act or a state act or a body owned or controlled by or aided by the government. So any private body aided by the government substantially will also will be considered as part of government establishment, or a local authority or a government company or a department of the government. So that's government establishment. Now coming to public building, I am highlighting certain definitions and I put together those definitions on same slide, so that because they're all interlinked from the perspective of this act and from the perspective of various benefits that flow, various mandates about accessibility and some other conditions that flow out from this law. So let's see what is public building, what are public facilities and services, because accessibility sections are applicable to these two and on all these three. So since accessibility sections are applicable, I put all of them into one slide. Public building would mean, earlier public building would mean only government building. But now public building would mean any building, a government or a private. Only condition is that either it is used or accessed by the public at large, including a building used for any of these purposes, which can be educational, vocational, workplace, commercial activities, public utilities, religious, mandir, masjid, gurudwara, any religious function that is taking place, yagashala, and cultural, leisure. So you have all these book societies, libraries, etc. Leisure would mean any place of tourist interest and recreational activities, medical or health services. Law enforcement agencies would mean all police stations and all these quasi-judicial bodies and mediation cells and centers. Reformatories and judicial forums would mean all jails and all these which are created for juveniles or for the correctional homes, etc. All courts and quasi-judicial bodies need to be accessible. Railway stations, platforms, roadways, bus stands, or terminuses, airports, or waterways. So waterways is also covered. All these are considered as public building. So that means all these public building would need to incorporate physical accessibility as per this particular law. I will see what are those requirements. Then public facilities and services. Now there is also a time period given in the law that we talk about subsequently for making a public building accessible. So it's a 5-year period that is given, that we'll be doing it later. For public facilities and services, there is a 2 years window that the law provides that they need to be made accessible. And what is public facilities and services? It includes all forms of delivery of services to the public. And this delivery would mean what? Housing, educational and vocational trainings. So some of you were raising a question about RERA and housing and public housing. This eventually need to meet accessibility requirements because this is to be considered as a service again. So educational and vocational trainings, employment and career advancement, shopping or marketing. So all the malls and all the shops and all right from the barber shop to a dentist shop or dentist clinic, they would be governed by this section. Religious, cultural, leisure or recreational, medical, health, rehab, banking, finance and insurance, communication, postal, information, access to justice. Now you'll see access to justice as a service. We'll be talking about it subsequently. I think in the next session that we have detailed about access to justice, but access to justice is a service defined by this particular section. Public utilities, transportation. Transportation is also a service or a public facility. So they all need to incorporate accessibility. If they don't, then a person with disability has got a right to go to the court and knock the doors of the court and say that my fundamental rights of these or these provisions of this section have been defined by the appropriate authority of the state or the public body. Similarly, it also defines information and communication technology. And again, for this also there is a time period given, and this includes all services, innovations relating to information and communication. So that means all your OTT channels need to be accessible, all your TV programs need to be accessible, including telecom services, web-based services, electronic and print services, digital and virtual services. So this all are a part of ICT, information and communication technology. So whole gamut. I think this clarification, this reading aloud makes us realize as to how much the country is still to do, and we are not yet there. And it actually, this law casts upon a huge responsibility on us as activists, as students of disability studies and practitioners in this area, or as rehab professionals. Transport system is also defined, and which includes road, rail, air, water, paratransit system, and for the last mile connectivity, that would mean the rickshaw, the taxi, or door-to-door service for picking up people, and which need to be accessible, of course. And then road and street infrastructure. Transport system does not mean only the rolling stock, but you will see also the road and street infrastructure. That means your sidewalk is a part of transportation system. Your street crossing is a part of transportation system. So if it is you're crossing the street, your subway systems, which often are stepped and lifts not working, they're a part of transportation system, and they need to be accessible by law. So that means you can see how much is still to be done. Universal design, I think we did yesterday, so I'm not repeating that. Let's quickly go over to rights and entitlement. And let me also keep a check on the time so that I am within my time. Okay. The rights and entitlement from section 3 to 15 talk about rights and entitlement. It will cover equality, non-discrimination. We'll do a little more because there is a lot of debate on section 3, which I want to highlight. Then 4 talks about right of women and children with disabilities, and it actually says that children with disability.
Subhash,
Yes.
this is very content rich. So just a tiny bit slower.
Okay. Thank you, Arun, for alerting me, because I was feeling, because I was perhaps rushing to, I'm so sorry, because of the time constraints. It's 7:20, and
Yes.
I think that I have time till 8, and I also want to leave sufficient time for question and answers. So I'll try to go slow, definitely. I'll go slow. So Section 4 talks about rights of women and children with disabilities, and children need to be consulted as per this act for anything and everything that concerns them. I don't know how much that is happening. It's not really happening currently. Most of the things are decided by the adults, right? Whether it is an access to park in the neighborhood, or it's about what course they want to study or what exemptions they want. I can relate to this example from Punjab, where the Punjab government perhaps just exempted all students with disabilities from many of the subjects and many of the sections. I think whole subjects was slashed by 50% for children with disabilities. And I think organizations rose up and to say that, why are you reducing the standards of education only because the children have disabilities? So the right thing is to consult, and that's what underlines the Section 4. Right to live in the community, Section 5. 6 is protection from cruelty and inhuman treatment. 7th is from abuse, protection from abuse and violence. Reproductive rights is covered in Section 10. A woman has complete control on her body and she should be deciding, not others, as to when she when to have pregnancy, how she wants to lead a reproductive life. Accessibility in voting, Section 11 is important. Justice 12 will not be touching this because I want to leave it for the next time when I have a full session on this. Legal capacity will be touching a little bit, Section 13, and provision of guardianship. So we'll be touching a little bit because it's a section, the law is huge and we have limited time. So just touching on important things. Equality and non-discrimination, Section 3 is most debated section ever since the law actually came into being and was notified, because the word legitimate aim has been argued so much. So actually this section says it actually casts a responsibility on the government that it will ensure, it shall ensure, whenever the word the shall is used in a law, it is mandatory. It is mandatory. And we can always take it to the court that yes, the law provides this and we have this right and this shall be ensured. So the persons with disabilities enjoy the right to equality, life with dignity and respect for his or her integrity equally with others. So you'll see the lack which we found in the last session that we did about Constitution, where we found that the disability was not defined when equality was explained, that yes, everybody will be treated equally in terms of whether nobody will be discriminated on the basis of sex, creed, and on all those conditions, but disability wasn't there. And that is supplemented here in this section, which is important. And it says that the state will take step to utilize the capacities of persons with disabilities by providing appropriate environment. And the reason for adding this section was that persons with disabilities are not to be treated as unworthy of any work. So their capacities, because they have capacities and they need to be utilized by providing an appropriate environment. The whole focus is give them an appropriate enabling environment so that they can use their existing capacities. And that's very important. 3.2, I consider this as very important. Third is, it says, yes, it's underlying principle that no one will be discriminated on the ground of disability, no person, unless it is shown, now this is being debated, unless it is shown that the impugned act or omission is proportionate means of achieving a legitimate aim. Now, what this legitimate aim is, and that means a person can be discriminated by the reason of a legitimate aim. For example, an organization thinks that it is legitimate aim to protect or I mean, aim could be anything. I give an example. Recently, the central government has exempted certain like police forces and IPS and some other services, especially paramilitary and other services, from the provisions of this act. So it seems that the government has considered that as a legitimate aim. So if you see, the law actually condones the discrimination if it is shown to have a legitimate aim. So one side, and discrimination is defined, as I said, in section 2H. And we need to understand this and read this side by side, that it says, yes, nobody will be discriminated, but it also somehow condones a discrimination if it has a legitimate aim. So that's what I wanted to underline here. And it also says that the state will take necessary steps to ensure reasonable accommodation. And when we are going into the rules, and the rules very clearly, RPWD rules 2017 clearly provide that reasonable accommodation, again, is a mandatory stuff. And the cost of reasonable accommodation has to be borne by the state or the establishment, whether it is private or state. It will not be passed on to a person with disability. You can't say that you need a JAWS software, so you pay. No, it's an organization that needs to buy it as a reasonable accommodation or a level playing field. Quickly coming to other sections, section 5 is community law, community life, where it says that you can't shut the persons with disabilities into institution. You can't say this is not your place to live in community, go and live somewhere else. I mean, I found certain these kind of activities happening in the community where a person with psychosocial disability and the RWAs, I mean, these cases keep coming to us where they sort of insist that such people be not given a flat or a housing in the society because this will disturb them and they have no right to live here. Let them be somewhere outside this community. So the law says, section 5 says, no, persons with disabilities have a right, and it says shall, to live in the community. They can't be forced to live in a certain arrangement. They can't be obliged. And they need to be given access to a range of in-house, residential, and other community support services, including personal assistance necessary to support living with due regard to age and gender. So the law is so, I would say, aspirational, but how much have we fulfilled those aspirations? That is something that we as activists need to constantly discuss and ensure that it is being discussed at public platforms, and the government is pushing this agenda forward. 11 and 12 talk about accessibility in voting and justice, so I'm not spending much time on it. Legal capacity is something that I want to spend some time on legal capacity. So, you know, in the past, what happened was, because of person with, there is a person with disability in the family, eventually girl or the boy, I mean, women have actually faced a lot of marginalization in the past, that they were not, they had no rights to the ancestral property earlier. So it is just boys who will get, and girl will be going to a different family, so they don't belong to this family. But the current law says no, the boys and the girls, sons and daughters have equal rights. Similarly, persons with disabilities were facing very similar situation in practice, though the law accepted them as persons with disabilities, but very often the legal capacity was questioned, and whether that they have no right to inherit property, and property was divided in the able-bodied siblings, or if the family had a disabled person, the siblings of the father would actually have those that property. That was a practice in many places, and this section actually questions that practice and says no, every person with disability will, and this is the government's job, the government shall ensure that they have a right equally with others to own or inherit property, immovable or movable, control their financial affairs, and have access to bank loans, mortgages, and other forms of financial credit. So this section settles down all the issues that banking system were creating for blind people, that they can't sign, they can't have credit cards, they can't have checkbooks, they can't do this, they can't do that, and they need to have it jointly with somebody else. So this thrashes away all their arguments. The other thing is that creates rights for daughters with disabilities as well to be an equal holder in the ancestral property, which so far has been, because they were double marginalized, disabled and women. So this section is pretty good, but we need to see how it is being implemented. So that's something that we constantly need to be on lookout. It also says the last one, which is the legal capacity also somehow touches upon and continues to profess, and this is there is a lot of discussion on this, that though it is said to be dismantling the guardianship provision, but in some of the other form it is actually coming back, and though in form of limited guardianship, but then eventually it says if this is not working, then probably the person will be given full guardianship also. Just look at this language. When a conflict of interest, this is here, when a conflict of interest arises between a person providing support and a person with disability in a particular financial, property, or other economic transaction, then such supporting person shall abstain from providing support to the persons with disability in that transaction. So this is good. But then there were other ramifications of this. Parents are not able to support the children. So then this provision had to be inserted, and this is misused at many places, which is provided that there shall not be a presumption of conflict of interest just on the basis of that supporting person is related to person with disability by blood, affinity, or adoption. So what we are finding, the family members in many cases are practicing or questioning the ability or legal capacity of this person and taking decisions on their behalf, which sometimes are not in the interest of that person. So many such cases come. Today, in the interest of time, I may not be talking much about it, but the many cases have come before me where persons have been denied of the right by their own family members, by own siblings. I'll quickly go over to the next. There's a guardianship, a provision for guardianship, which is continuing in some of the other form, though it says that only limited guardianship will be provided to take legally binding decision in consultation with such person. But then there is a lot of subjectivity whether how this consultation will happen and whether how much undue force or undue, would say, influence will be used during this consultation. So that person gives in to a certain, say, decision being taken by that guardian. And this also in some form continues that it says that district court or the designated authority may grant total support to the person with disability requiring such support, or where the limited guardianship is to be granted repeatedly, in which case the decision regarding support to be provided shall be reviewed by the court. And so that, so person will be given complete support. It may be needed actually in many cases, but then though it defines what will be limited guardianship, it says it has to be a system of joint decision making, which operates on mutual understanding and trust between the guardian and person with disability. Now, this is a huge issue when we are talking about mutual understanding and trust between guardian and the person with disability, because unless there is a third party intervention or at least a light, I call it, जहाँ भी sunlight पहुँचती है वहाँ पर बीमारियाँ नहीं होती, infection नहीं होते. But very often these are personal within the families or between two people. Outside people have no, I would say, knowledge, or the light isn't there. There is no intervention of outside people. So therefore, this provision has huge issue of being, misused against the persons with disabilities. Section 15 says that appropriate government shall designate one or more authorities to mobilize the community and create social awareness. And how to mobilize the community is not actually defined anywhere. It is also left very subjective, and it is left to the state governments as well. Most of the state governments haven't done much, haven't taken much step on this issue to designate authorities who would mobilize the community. So most of the work has actually fallen on Department of Social Welfare, and who typically do the work in form of some pensions and assistive devices, and they don't go beyond it. So these are areas that we need further exploration. I'm just going to be doing some more highlights. So education, right to education, it is covered and it touches upon inclusive education. It ensures that every school will practice inclusive education. It won't refuse admission. And it will provide sports and recreation facilities. It also says that educational buildings, facilities, and campuses will be made accessible. Reasonable accommodation will be provided, and education to deaf, blind, and deaf in education will be ensured in appropriate ways. Transportation facilities will be provided, and teachers will be trained, including teachers with disability who are qualified in sign language and braille. So that means education institutes must incorporate and hire teachers or sign language, teachers who are trained, and teachers who may be deaf as well, to teach deaf children as well. So there's so much given in this, but is it really happening? Have the states done their duty to change their, say, recruitment practices? Have they changed their systems? Have they created posts for these educators or the sign language interpreters or teachers who are teacher with disability, who knows braille, who knows sign language? It also says to provide appropriate augmentative and alternative modes. But what has been done this far, mostly the resource centers that are created in a block or in a setup are not really full resourceful. They lack so much of resources. There are no human resources. There are no technologies available. So these are, there's a lot of subjectivity and a lot of work needs to be done to realize the mandate of this act. It's a wonderful act. And this is what the action is. That was the highlight that I just put. So I'm just skipping it quickly. It also talks about conducting surveys every 5 years to ascertain the special needs. And this first survey was to be done in 2 years. And we are not sure how many states have actually done this survey from the commencement of this act. So you need teacher training institutions. So all these are actually shall take. So that means these are mandatory requirements from under this law, which requires state to act. It also talks of adult education. And adult education would mean that persons with disabilities who have crossed the age of 18 would also be provided support in continuing education programs equally with others. So on all these programs, touching upon how rules talk about education. So to support that section of education, Chapter 3, Rule 7 talks about to implement these, there will be a nodal officer in each district education office. So that is the rule provides that in order to implement these sections, there will be a nodal officer in each district education office and to deal with matters related to admission and the facilities to be provided. So this gentleman and this officer, nodal officer in every district education office can be contacted if any child is facing any problem. So implement sections 16 and 31. Coming quickly to employment. Employment, from looking at the earlier law, a lot of change we see now. Though the language was a little more confusing in the earlier law, but the interpretations that were provided of the section 33 of the PWD Act 95, we developed a wonderful case law. And we were, and it was that section 33 of the last law that led to interpretation from the topmost court of the country, the Supreme Court of India, which clarified that reservation would mean reservation in group A and B also. You can't just say that we'll give in C and D. And that was a result of that interpretation. If you find in the current law, the reservation has been actually put on the back burner and it is literally left to the states to respond to. And this is, I find this as a major concern in this law, because despite the court being categorical on reservation clauses in employment, the current law does not say anything specifically and just literally leaves it onto the state. And in fact, let me also highlight one more thing. The UN Convention we have implemented this law in light of UN Convention. And UN Convention also says that in a country, if some facilities or some benefits and some rights are already being given under the existing framework, they shall not be reduced or taken away in the name of implementing the convention. But I'm painful to say that yes, in the name of implementing the convention, in this law, the right to promotion has been not been categorically defined, and it's just been left to state. So that's one of my major observations that probably practitioners and activists can further follow upon. For non-discrimination, the highlights are that the organizations, every government establishment shall provide reasonable accommodation and provide barrier-free and conducive environment to employees. It also talks about maintaining records of persons seeking employment by the employment exchange. It also talks about every establishment, that means both private and the government, they shall notify equal opportunity policy detailing various measures that's proposed to be taken by them. And then all government organizations need to appoint a grievance redressal officer. In every government organization, there has to be one grievance GRO, and who will have a register of complaints, etc., etc. And then there's a procedure that is given in the rules. And so so you will see the grievance redressal officer will maintain a register of complaints in the manner prescribed by the central government, not appropriate government. So in this area, the central government has already provided this thing. And every complaint should be required within 2 weeks of registration. This complaint shall be inquired. So this is something that is given, not left to the state. This is given by the central law. So section 20 is what it talks about it. And it also says that the government, it leaves on to state governments as well, that they can frame policies for their postings and transfers. So earlier the law was, the rules were that persons with disabilities will be posted and transferred as far as possible to their parent state or district, or as far as possible to persons closest to the person's home, thinking and assuming that the person would require some support of the family and the place that he is aware of. The new places may not be accessible, he may not know people, but that seems to be, of course, has been implemented by many organizations, but it may not be possible at senior posts. So this is left to the exigencies of service if I look at various rules. And similarly, the law also has left it to various governments to frame policies. Moving on to next, the policy, 21, this is section 21. So every establishment, which includes private and the government both, that they will notify equal opportunity policy. And what are they going to do to implement the provisions of this chapter? And then every establishment must also register this copy of this EOC to the chief commissioner if it is a body under central government, to the state commissioner if it is a body under the state or under any state. So this is again a mandatory requirement. You'll find the words used are shall. And in both the areas, the words used are shall, but it is to be seen as to how many states have implemented or created rules, and their state commissioners who are functional or non-functional have taken any effort to ensure that all the establishment in their states registered under various laws, whether society or trust or companies or partnerships or shop and establishment or any other law that's created in that state, have they registered them, or have they registered their equal opportunity policy? Have they even sent a notice? So this is again a huge area of work by many states. I can tell in the state of Delhi, during the time of the previous commissioner for the state, Mr. T.D. Dharyal, so much work has happened that most of the states in Delhi and various establishments have already notified their policies. But only one thing that I feel pain to see is that most of these policies are not accessible. They're scanned copies. And I've been advising them, please don't have these scanned copies. They are against the mandate of accessibility. But nevertheless, this section has been implemented by many of these organizations. GRO I just spoke about. So a GRO has to be appointed by all government establishment, and any person who is aggrieved will approach to them, and then you will find this section also provides creation of a new body which is called District Level Committee on Disability, who would be working as kind of appellate body, or somebody who's not happy with the GRO's decision can eventually go to this district level committee wherever he has any grievances still left out after the GRO has implemented his legal mind onto the complaint. So district level committee, many states have established, like UP has. I'm currently in UP, I was traveling in UP, and I was only inquiring in the field as to have they created this district level committee, and is there convergence with various other laws. So this committee typically is headed by the district magistrate, and there are all departments who are on it, and then there are 5 persons with disabilities usually representing different disabilities, and also there need to be women representation, gender representation, and NGO working in that area on that front. So this is typically the composition of district level committee, but eventually this is left on to the state to create these committees. Quickly coming over to chapter 5, I'm nearing 7:40, it seems. I'll have to rush, Arun, if I have to connect to my next meeting. So the social security, the only problem that I have highlighted in red is that it still retains the term which I am very against, is within the limits of its economic capacity and development. And because of this section and these terms, many states have continuously restricted and not done anything in terms of what will be the amount of disability pension. So pittance, you saw a report a month ago or probably earlier this month, that we have a pittance from 300 rupees a month as disability pension. And I think that's the lowest sum, and few going up to probably 3,500, perhaps Goa, and UP probably has increased recently from 500 to 1,000. And I think people have already got some part of it for last 3 to 4 months. So there's a huge gap on this. One more section that people are not aware, which is a provision to this section that should be implemented and should be highlighted, which is quantum of assistance to persons with disabilities under such schemes, which are usually for providing adequate support and adequate standard of living, giving rations, giving assistance. It will be 25% higher than is applicable to others. For example, a non-disabled person similarly situated is getting a pension of 1,000 rupees. The person would get 25% higher if he's a person with disability. So these schemes, these are not really, people are not really aware of these. Many governments are not aware of this, and this is not really done. So as I said, what gets impacted by this limit of economic capacity? I just spoke about pension, but the community centers, which are to be created for abandoned people and people who have no shelter or livelihood during disasters. Now, how can you bring economic capacity during disasters and in the area of conflict? Now, come on, I mean, in disaster, everybody needs a human life is a right. You need to give them. And then sanitation facilities in urban slums and rural areas. I mean, that is a basic living right, Article 21. How can you subject it to economic capacity? There has to be an accessible toilet, but I mean, that's what safe drinking water. These are already being read into Article 21. So you can't really subject to within the limit of economic capacity by the states. So I feel somebody can actually go and challenge it in Supreme Court, saying that this is defying the Article 21 completely. That's a right, and here you're subjecting it to a bureaucrat sitting there and deciding, oh well, my finances do not permit this. Similarly, it's also impacting aids and appliances, that there's a limit set that you can't give a costly wheelchair to somebody who needs that one for his postural adjustments. Unemployment allowance, I already spoke. Disability pension, I spoke. Caregiver allowance. Caregivers and writers are given a pittance, and how much can they do? You can't hire professionally trained people. So this really doesn't work, especially for high support needs. Similarly, insurance schemes and all. So all these areas are getting impacted because of this funny things that is added into the law. Healthcare, it says barrier-free access. Insurance, it talks about culture and recreation. It talks about where it talks of access and equal rights. Sporting activities, you want effective participation in sporting activities, and for which accessibility is needed. Free education, as I said yesterday, when we were doing the constitution, that not just by that constitutional amendment for persons with disabilities, age is 18 years. Free education for children with benchmark disabilities, and non-discrimination for all disabilities. So there are some provisions which are given to benchmark. For benchmark, it is free. If it is less than benchmark, then wherever there are charges, they'll have to pay. Similarly, there's a reservation in higher education, and this is about 5%. 5% in the higher education institution for benchmark disabilities, and in the employment it is 4%. And there is also upper age limit. And these various provisions in this chapter are for people who are with benchmark disabilities. So reservation in the jobs, 4% for different disabilities. This time they have clubbed many disabilities into one. So many people said that you have actually taken away more than what you have given us. So earlier, at least we had 3% for these 3 specific categories. Now you have given just 1%. You have added, and you've added so many conditions. So people, disabilities that were earlier there in the law, they felt cheated. Many of them actually also crying foul that they should have been actually 5%. You shouldn't have reduced it to 4%. Eventually, the losers are majorly in the locomotor disability space, and blindness and low vision, most of it they have retained. Deaf and hard of hearing have also retained, but the major challenge has been to category C and D, who probably have a reduced share of the reservation in the jobs. So I'm quickly moving on because the time is less. It also talks about incentives in the employment to private sector, so that private sector can employ more people. Again, there is a limit to economic capacity, and I think the government has been giving some provisions where it says for a certain number of years we will give you your PF and gratuity contributions. The state will directly provide if you are retaining them, persons with disabilities. So, and it talks of special employment exchanges and special schemes and development programs. So all 37 actually talks about all schemes and development programs, which are, first of all, they need to make these schemes, and in existing schemes, you need to provide 5% reservation. This is not really being done. In fact, I'm contesting one case against UDA where all these shop allotments and business allotment, the spaces for business allotment need to be given these reservations. So allotment of land on concessional rates, especially for businesses, setting up occupation and businesses. And there's a huge fight with the DDA saying that this is only source for earning for us and all that. They say we can't give it at concessional cost to persons with disabilities. There are provisions for special high support needs where the people will be assessed, and any person with a person with disability or an NGO, they can write to the concerned authority, that is appropriate government, and who would an application that they need high support, and then on receipt of this, an assessment board consisting of such members, and these members central government will provide as to who will all be the members, not the state. And this assessment board will decide that who needs what level of support, and then it will be support will be provided subject to relevant schemes. So again, it is subject to relevant schemes, and the schemes are not yet out. Awareness campaigns, 39. Let me come quickly to accessibility that I thought was most important. We just have 5 minutes to go. I'm so sorry. 40 talks about that the central government, that means different ministries of the government, in consultation with the Chief Commissioner Office, they will formulate rules for persons with disabilities, which will lay down standards of accessibility. For which areas? Physical environment, transportation, information, communication, other facilities, including technologies and services, which are to be provided in rural and urban areas. So you'll find many of these standards currently do not address services to be provided in rural areas separately. And currently we just have few standards that are on physical environment, basically built environment, bus body code. I don't think that still requires a lot of changes. And then you have website standards and the public document standards. So these are currently issued under the Rule 15. Many others are currently in the making, and different ministries are coming out with their drafts. They're being circulated to the sector. This is time for all of you to be very active and expect that these are given very short notices, and you should engage and pass your comments, give your comments within those deadlines, so that they are really representative of the sector's needs and not the certain experts have just decided as to what is good for you and ministries have decided what is good for you. So I request all of you to actively engage in the standards making that is currently happening in the country. Some of them have already come in. So this is 40 is about transport. 41 is about ICT, where it talks of all contents, audio, print, electronic media. You read the communication, all that need to be accessible. Electronic media, all audio description should be there for blind people, sign language interpretation should be there, closed caption should be there for deaf people. So this is already a part of law, a part of section 42. It also talks about electronic goods and equipments which are meant for everyday use. They also need to be made available in universal design. So that means a larger variety of people can use it. You just can't say that this product is only for able-bodied. It has to be done in a way that large people.
Hi, Shubham. बस ठीक तुम बताओ बढ़िया.
I would request whoever is talking, if you can just please mute your mic, please. Thank you. The consumer goods, measures to promote, develop production and distribution of universally designed consumer goods, not yet has happened because it is also mandatory requirement. The BIS is perhaps working on consumer products accessibility and accessories for general use. And I think some national institutes are also focusing on this, but we as a sector need to be a little more aware. 44, mandatory observance, it says the establishment will not be granted permission. There are two levels of checks, that any building which is coming up, you won't get permission if you're not accessible. Second level check is you won't get a certificate of completion, or you won't be allowed to take occupation of a building if it is not accessible or does not adhere to the rules. So there's already a section 44 that can be actively used to check all the buildings that some of the ULBs, that is urban local bodies, are trying to just give just a pass. Okay, they have come up, let us give them under some pressure, some political pressure. If they are giving them, okay, then please hold them in the court. After the enactment of this law, no building can come up which is inaccessible. An existing building also, there is a time period to make them accessible if they are public buildings. And when I say public building, this also include housing. This includes any building which is for public use. Please do take recourse to law wherever you find this is not happening. Why I'm saying is also because take support of section 45, and which says within a period of 5 years, and it also says that each organization who are responsible to make these buildings accessible, they just can't. This section 2 was created, subsection 2 was created purposefully so that organizations should not, wake up on, I would say, the 11th hour, saying that, oh, 5 saal ho gaya, abhi humko accessible karna hai. So it actually gave 5 years for doing activities under section 2, which is to formulate and publish an action plan based on prioritization as to how they will provide access in those 5 years. So this has actually not been done already. I think it's more than 3 to 4 years have passed. And this is something that we as activists and practitioners need to check. And I'm sure because of their delay, because of our sleeping, the most governments will grant them some extension. Okay, you do it after 1 year. Okay, do it after 2 years. So this as a sector, we need to check. Similarly for service providers, there is a period for 2 years. I told you what is included in the services. So I think I'm just going to stop here and just close because I have another meeting at 8, and
Thank you, sir.
I can maybe take 1 or 2 questions quickly.
Yes, sir, sure. We can take up the questions in the next session, I think. And I'll just wind up with the formal vote of thanks.
Yashaswini, just a second. I need to make a small announcement before you take. So guys, there has been a small change in the schedule. The lecture that was scheduled listed for the 23rd February has now been shifted to 1st March because of the unavailability of the concerned resource persons. So please just note that there will be no lecture on 23rd. Now the next lecture is on 25th of February on inclusive education. The link will be shared with you all. And the first periodic test will be conducted on 28th February, and the instructions for that will be given to you at a later stage, maybe during the next lecture. And you'll have one, and the lecture that was originally planned for 23rd is now on 1st of March. Thank you. Yashaswini, over to you.
Yeah. So as we complete a 3rd lecture of the course, I would like to take this opportunity to thank Subhash sir for the wonderful and engaging lecture accompanied by the very informative PPT to broaden our understanding of disability studies. Thanks are also due to our interpreters, Arun sir and Preeti ma'am, for their valuable time and effort. Last but not the least, I would like to thank all the participants for being a lovely audience. Thank you one and all. And the details of the next lecture have been already been shared. Thank you.